Good morning. How are you guys doing? How are you guys doing? Somebody say, why is Mel wearing a pink shirt? You know why. No, I'm just kidding. I like pink. Trolling, maybe? I don't know. I mean, maybe you don't know me. Maybe you don't know me. Good morning. What's up, guys? I hope you guys are doing good. Tell me, can you do a quick sound check? Does the sound good, guys? Because you know we had some issues with that. Does the sound good? Oh, bad audio again? I'm gonna fix it, guys. Be patient with me. I tested everything before. Everything was fine. I hit go live and then boom. Oh, God. All right, let me mute that. Is my voice staticky too? The whole thing is staticky? Oh, Lord. You know what's crazy? This is like an expensive sound device and I have all these issues. Choppy. Yeah. Yeah, the whole thing. The whole thing. Let's see. Story of my life. All right, I'm trying to get this thing going. Mic check. Yeah, I might have to restart OBS. So staticky. I might as well just hang on here for a second. Let me stay in the stream. I want to restart it now. It's better to restart it now before the hearings start, and let me fix the audio. And I have to resolve. I already reached out to a company to try to resolve this, and I sent them the stuff, but it's like default responses. So yeah, let me do that. Love you. Let's see. All right. You guys let me know. Is the audio fixed or what? Oh, they had to turn off rewind on Rumble. Mine is a hardware issue. I can see the problem. It's like it's kind of it's a very kind of complicated somewhat thing that's like for some reason OBS keeps losing the audio device. I forgot the word that it's called. How's it sound? Is it good? We're clear? Okay. Yeah, I'm gonna have to resolve that issue. All right. Let me start the multi-stream that I know now that I know we're good. And we'll talk a bit about today, what's going on, what's happening. I want to know how you guys feel about this case and trial. It's a very divided case. People are pissed. I was up late both nights, back to back, so I'm a little tired, but um I think the audio is like OBS loses it and it's failing to initialize. Uh, Good morning. Good morning. I don't know if I should play some clips too from this guy that has a lot of the Lindsay Clancy clips. What's his name? Let me see this guy. He has a lot of the woman. She has a lot of support, a lot of women out there standing with her, relating to what they're going, what she did with killing her kids or depression or postpartum depression. Bum, 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 bum. Luca, I am your father. Let's see. Take a little look here. While I still am getting set up.
Is it just me, or is loneliness becoming so much more of an epidemic nowadays? Like, are we all just really fucking lonely? Because I'm pretty fucking lonely. It feels really hollowing and isolating.
Chewing on something. I just got home I passed by the church, and on the, you know how they have those little marquee signs that are interchangeable each week. I drove by this church, and it said, let go of your anger and your rage and have peace in your heart. And something about that just pissed me off. And it pissed me off because it was the realization that if you are seen as an angry woman, then you're problematic. And you know what? We're not angry enough. We're
Mm.
not pissed off enough. If we were more pissed off, the laws and the rules and the expectations from us would change. But then you have culture and you have religion dictating that if you're going to be considered good and, you know, a pure Christian, or whatever you want to call it, whatever theme or flavor of religion you subscribe to, whatever, it's relevant, is to let go of your anger, to release your anger, to not feel and process your anger. You know what? Unexpressed and unprocessed rage causes autoimmune disease. It causes cancer. It causes stomach issues. It causes anxiety. It causes migraines. You name it. Unprocessed anger and rage, it'll find a way to surface. I promise you, it will find a way to surface. It's almost like, you know, when you sit on an inflated beach ball. You remember when you were a kid at the pool and you'd push the ball under and you'd balance on it for as long as you could, and all of a sudden the ball would come shooting up into the
The
sky,
hell is
and
she
then you
talking
laugh
about?
about it. That's what unrepressed or unprocessed anger is.
Mm.
You can push it down. You can balance your life around it. You can perform and show up and do the good thing and go to church and
Mm.
subscribe to everything about what it means to be a good person. All the while, you're boiling mad on the inside while society has conditioned you to, no. Don't do that. Keep serving, keep performing, keep demonstrating all of this unpaid labor. Keep
Unpaid labor.
keep bleeding out
Oh.
energetically. Keep serving, keep allowing. And that means you're good, and you're gonna get your pathway once, whatever, after you die. Stop it. We need to get more pissed off. Look
Mm.
around. Look around. Look at everything going on in this world. I think a lot of the mess that's going on in this world today would be cleaned up with a lot of pissed off women.
Oh.
They don't want us pissed off. That's why we should be pissed off.
Pissed off woman. PO'd. PO'd. I wonder what the first poll we should do today is going to be. Let me get the chat up too. We get the chat up. The chat up. I'm going to play a clip too. Who's in the chat? Rachel, Layla, Hoax. Hoax, what you think, man? I already know. I kind of know what you think, I think. What you think? Shorty, what you think? Let me, I feel like I should do like a mini. I don't want to do a whole recap. I did a video for that already, and that shit was like long. And I tried to look at the whole recap this morning, and yo, bro, I was like disoriented, trying to like look and read at everything. Um, so Lindsay Clancy, okay, she is in the courtroom, and they're not arguing whether she killed her three children. Whether though some people are saying she's been brainwashed and she didn't kill the children, and that the actual ex husband did it, and all this stuff, and all this, But today is closing arguments. You have Sullivan and the prosecution. They get 1 hour each side, from what I read. And I don't know who goes first. I thought the prosecution goes first. I don't know. We'll see. So, if you don't know, Lindsay Clancy was a labor and delivery nurse at Mass General Hospital. The three kids: Cora, 5 years old; Dawson, 3; and Callan, 8 months old. That afternoon was an ordinary, and she had a pediatrician appointment, I think, that morning. And then she was playing with the kids in the snow earlier that day. And then she texted the husband photos of the kids. And then around 5:15, she sent them out for a prescription. I think it was something at CVS. I don't know if it was actually a prescription. And some takeout food. He had been gone supposedly for about 45 minutes. He came back to a silent house. and a locked bedroom door. There was blood and an open window. He found her in the backyard, paralyzed because she jumped out of the window. And she told him the children were in the basement. Cora and Dawson died that night. Callan died 3 days later. And the defense, they're saying she has postpartum psychosis or had bipolar disorder, which made things worse. And also, she was heavily medicated by providers, a lot of medications. Prosecution says that she planned it. She created a window by sending her husband out and planned out the day and was acting normally with everybody else, it seems like, and never told a single family member about a voice. And I feel like the voice thing is going to come up. You guys heard about the voice? The voice thing? A voice was telling her to do these things, and it was a male voice. And some people think that male voice was the husband, Patrick. Because Patrick was the one telling her. It was the voice. That's the voice that she heard. It was Patrick. Oh shit! But I think the voice came after this whole situation happened. Supposedly. Um, the experts say major depression, not psychosis. Their sharpest fact is that she told a psychiatrist that what she said to her children while unaliving them was go to God, which is just crazy. So most people assume that her lawyers have to prove that she was insane. And what actually is the case is that the prosecution has to prove that she was sane. You know what I mean? The defense doesn't have to prove anything, really. The prosecution has to prove that she was actually sane of mind when she was doing what she was doing, that she wasn't actually in this thing. And let me see. So now the other big thing too, guys, manslaughter was added. So you have first degree murder, that's life in prison, no parole. Uh, Second degree murder is life with parole after a term the judge sets. So it could be 15 or up to 25, I think. I'm not sure. And then they added manslaughter. So they added like a middle ground, kind of. I don't know how you guys feel about that. That wasn't there before. I mentioned it in the last live I did covering this. So Sullivan signaled jurors will be allowed to consider it. The defense fought for it. Prosecutors opposed it. I don't know what the outcome can be. If she just gets manslaughter, what does she just walk out that day or some shit, or she, I don't know, or like a smaller sentence or whatever. And then there's also not criminally responsible, which if that's the case, she doesn't just walk out. Apparently, she would have to go to a psychiatric hospital, be reviewed periodically, can run indefinitely while she's found mentally ill and dangerous. But also, I believe if the court finds she's no longer a threat or a danger, she could be released. And then, of course, there's also a hung jury. You know, I was really leaning towards hung jury. I don't know now with the manslaughter thing. I'm not so sure. I don't know if that gives them kind of an easy. I don't know. Report a spam. Who's spamming? TikToks who swear he was watching the camera. TikTok sleuths. TikTok. Let me look up some of the stuff that I have saved here. Let me see. Good morning. What's up, Rumble? Good morning, Rumble. Saying hi. On Twitch. Twitch and launch. Twitch. Got Twitch. Good morning, X. Nobody watches me on X, but good morning. I want to play. There's a couple things I can play. Normally, I would have like a whole thing lined up, but because of all the hardware issues I've been focused on trying to do that. I want to play a little bit of. I don't want to play this whole thing, but a little bit of Dr. Phil. Dr. Phil and Jillian Michaels. You think hung jury? I think hung jury too. The only thing with the middle ground is some people just like to land in the middle sometimes too. People just like, oh, we're just in the middle. We're not gonna. Some people don't want to make a decision in life too, so they just the middle ground is like okay, you know. I wonder if there's a feed of the outside of the courtroom. Like, there's a bunch of people out there cheering, Lindsay, we love you. We love you, Lindsay. Pink shirts with their pussy hats. Oh, that just reminds me of who I got to play. Hold on. This guy had a good video. Lobato. Libido. Where's he at? If I can find him. Scott Libido. Here we go. Here we go. I got the other thing ready.
About the ladies. I got respect for women, but only half.
Let me fix the volume too. The volume. Lobato. He recently had some kind of medical incident. I don't know if it was a heart attack or what it was at an event. I guess he's doing all right now. Gonna do
Half of you. The other half of you American women here just gone batshit fucking crazy. This fucking broad, Lindsay Clancy, admitted to strangling, slaughtering 3 innocent baby children, helpless, can't defend themselves. She slaughtered them individually. And half of you women in this country are running to her defense, giving her millions of dollars. A voice told her, these are the same exact white liberal women.
Oh, go.
Who scream women's rights with their pink pussy hats. This is definitely not a man's world. But yet you same women are pushing with all of your energy to allow big, bulky, strong men to annihilate you women in women's sports. These are the same exact white liberal women running through the streets with their scarves on and their masks, screaming from the river to the sea when they don't know what river or what sea. What they do know is that a large proportion of Muslim men, not all of them, treat their women like fucking shit.
Damn.
These are the same.
Kenneth, thank you so much for the super chat. I appreciate the support. Oh, yeah, I missed it because my stream was all messed up. I appreciate you, man. Thank you. The first one was 6 a.m. West Coast. I think drinking that fifth was a bad idea. Yo, were you up for the chase last night? Yep, the fifth probably was a bad idea. Your stream froze from my last dono, but not sent another one. But not sent another. Thank you, man. I think I got 2 of them. Thank you so much. Bro, me staying up late when I wake up the next day, I feel like I'm hungover. I guess just getting older. Just staying up late. And I'm struggling. I'm like, I'm delirious.
Exact women who turned a blind eye and are quiet crickets when these illegal alien men come in here and rape 12-year-old little girls.
Damn, that boy going off, bro. It's too early, Scott. Okay, I want to play some of this video. And we're going to get a poll here. I need somebody to just send me the poll questions. I can't right now. There's too much going on. Let's see. Julian Michaels and Dr. Phil.
People have to decide if it was just a mean and evil woman or an incapacitated and psychotic woman. And that's going to be the dilemma.
You got to decide. Yeah, the look that she has in the courtroom is fucking cold, though, man. Cold.
Are dead. Their mother, Lindsay Clancy, strangled them with exercise bands in the basement of their own home. And right now, while she's on trial for their murders, women are showing up outside the courthouse to cheer her on.
I think every one of those should be investigated.
Clancy.
Yeah. So let me just jump over here. I just want to jump a little bit. And I'll put when I have a chance, I'll put the link in the description. This is Dr. Phil.
To this, and it's called postpartum psychosis. And postpartum psychosis is a psychiatric emergency. And what usually happens is it is misdiagnosed, it is underdiagnosed. I've dealt with this when I was in private practice. I've covered a number of stories over my more than 2 decades on the air. And people, first off, don't want to confuse baby blues or postpartum depression with postpartum psychosis, because when we say psychosis, we mean a full and complete break with
Yeah. Spilled some on it. Those shouldn't be conflated. We talked about that last time too, the statistics. So they're about to start. The statistics between like baby blues, postpartum depression, and then the more rarer postpartum psychosis. And, not the same thing.
reality and an inability to distinguish reality from fantasy. And in many cases, including this one, there was a delusional disorder that is being reported where she says she was hearing voices.
Yeah, it's called LSD. Been there, done that. I'm just kidding.
That were authoritative and authoritarian and instructing her on what to do. And when you can't distinguish reality from fantasy, then
you don't listen to the voices if the voices are telling you to do shit. And here they're talking about the rarity, and I've already spoken about this, but we'll play it here again.
How common is this?
Well, it's not common, fortunately. Postpartum depression is much, much, much more common. Baby blues is much, much, much more common. Postpartum psychosis is a rare psychiatric emergency. It's occurring in roughly 1 to 2 cases per 1,000 births. So it just
1 to 2 cases per 1,000 birth. Postpartum psychosis. Because now on TikTok, all these moms, everybody has postpartum psychosis now. It's a serious thing. It does happen. And Lindsay, I don't know. She really might have had something. I'm not sure. I feel like she should be, held responsible and just not be let out. But some people are trying to argue, well, it was the drug companies and it was the medication and the healthcare system. That's another conversation that failed. I do think like a lot of these doctors just prescribe you whatever. You can go Google some shit, say, hey, what do I say to get this? And they'll fucking give it to you. Or if you're actually genuinely seeking help, good luck finding somebody that really cares or has the time to even listen to you. And then they'll put you on some random shit. Hopefully it works. Maybe it won't. We'll find out. And if you keep feeling worse and worse and worse, we'll keep telling you, we'll just keep taking it and ignoring your body. Like what your body's telling you, we know better than your own body. That's normal. Your body's adjusting the chemicals and stuff. So keep popping the pills and keep taking it. And if that doesn't work, and then now your body's dependent on it, we'll start weaning you off, and then we'll put you on something else. We'll do a test, and you have to take it for weeks on end because it takes that amount of time for it to fully work. And if that doesn't work, we'll do something else and blah, 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 so on and so forth. Let's see here. Okay, so let me just skip ahead. I want to play another interesting tidbit. Bloop, bloop, bloop. Bloop, 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 bloop.
But the big question I see a lot of people asking is if she's so unhinged and she's so psychotic and she's on all these different medications, how in the world did she plan this so meticulously? I mean, she literally calculated out the errands he was going to run so she would have enough time to kill each child.
Yeah, that's the conflict in this. And when you have these delusional voices and your conversation with the delusional authoritarian voices, because you're delusional, because you're psychotic, doesn't necessarily mean you're inefficient. It just means you're living in a fantasy world and you can't distinguish between reality and fantasy. But your functioning within that fantasy world can still be logical in an illogical world. You can still connect the dots in the fantasy world, even though it is a fantasy.
You know, I think too what people have a hard time gripping is just like, because Patrick had said that, like, he said it was like one of her best days, the day that she, did this to the kids. Obviously, before doing that to the kids, it was her best day.
And this is a very intelligent woman. She was a nurse. She was a nurse in this arena, actually. And look, I'm not explaining away what she did at all.
Yo, the audio again. Oh my gosh, dude. I don't know what to do. Let me see. I wonder if I do this. I don't know. I wonder if I can. If I switch this shit to that, will it work? How do I do that shit? Let's see. For now.
And she has a degree of accountability for what she did, and they're saying that the prosecution is saying it wasn't an earnest attempt to end her life. Well, you just have to the jury's going to have to make up their mind about that. She is a paraplegic for the rest of her life. She did use multiple methods.
This is a nightmare.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, before the court today, we have the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present.
Oh boy. What was that? Oh, is he starting? Oh. I'm gonna restart the thing again, guys. The OBS.
There's murder in the first degree and there's murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree on the following theories. First, that it was murder with deliberate premeditation, And then second, and or it was murder with extreme atrocity or cruelty. To find the defendant guilty on any of these theories of murder, you must be unanimous. That is, all of the deliberating jurors must agree
Is the audio okay, guys?
that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict slip as to each theory of which you agree unanimously. And I'll go over a little bit later the verdict slip and how that is going to be handled. Now, so if you're unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. So I'm going to begin by instructing you on the elements and the additional requirements of proof for each of these theories of murder in the first degree. And then I'll instruct you on murder in the second degree. All right. So number one, I'll first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. One, the defendant caused the death of Cora Clancy, Dawson Clancy, and or Callan Clancy. Two, the defendant intended to kill Cora Clancy, Dawson Clancy, and or Callan Clancy. That is, the defendant consciously and purposefully intended to cause Cora Clancy's, Dawson Clancy's, and or Callan Clancy's death. And three, that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. I'll now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Cora, Dawson, and or Callan Clancy. A defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Cora Clancy, Dawson Clancy, and or Callan Clancy. That is, the defendant consciously and purposefully intended to cause the death. The third element is that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even seconds. The key is the sequence of the thought process. And it would be first, the consideration whether to kill, second, the decision to kill, and third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then to decide to do it. In deciding whether the defendant intended to kill the deceased and whether she formed that intent with deliberate premeditation, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may form the required intent and act with deliberate premeditation even if she suffered from a mental impairment or consumed prescription drugs, but you may consider that evidence. Now, I want to talk about the second theory of first-degree murder, which is murder with extreme atrocity or cruelty. Now, you shall consider this theory of murder in the first degree regardless of whether or not you find that the Commonwealth has proved murder in the first degree with deliberate premeditation, which I just discussed. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. One, that the defendant caused the death of Cora Clancy, Dawson Clancy, and or Callan Clancy. Second element, the defendant either A, intended to kill Cora, Dawson, and or Callan Clancy, B, she intended to cause grievous bodily harm to Cora, Dawson, and or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant a reasonable person would have known created a plain and strong likelihood that death would result. The third element was that the killing was committed with extreme atrocity and cruelty. Extreme atrocity or cruelty, I'm sorry. I'll now discuss each of these requirements in more detail. The first element to this theory is that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. A defendant's act is the cause of death, where the act is a natural and continuous sequence, results in death, without which death would not have occurred. The second element is about the defendant's intent, which the Commonwealth must prove in at least one of three ways. These are that the defendant, A, intended to kill Cora, Dawson, and/or Callan Clancy, or B, intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, to this intent element, the Commonwealth satisfies its burden if it proves the defendant's intent beyond a reasonable doubt in any one of those three ways. The first way of proving intent, that the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation, which I discussed a few minutes ago. The second and third ways of proving intent are different from any element of murder in the first degree with deliberate premeditation. So, the second way is that the defendant intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy. Grievous bodily harm means severe injury to the body. The third way to prove this is that the defendant intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you to understand how to analyze this third way of proving the defendant's intent. You must first determine whether the defendant intended to perform the act that caused the death. So if you find that the defendant intended to perform the act, then you must determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether under the circumstances known to the defendant, a reasonable person would have known that the act created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant suffered from mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite intent even if she suffered from a mental impairment or consumed drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the third element in this theory is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in the taking of a human life. You must determine whether the method or means of killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's actions in terms of the manner and means of inflicting death and on the resulting effect on the deceased. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death with extreme atrocity or cruelty, you must consider the following factors. 1, whether the defendant was indifferent to or took pleasure in the suffering of the deceased. 2, whether the defendant's method or means of killing was reasonably likely to substantially increase or prolong the conscious suffering of the deceased. Or 3, whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person. In considering whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person, you may consider A, the extent of the injuries to the deceased, B, the number of blows delivered, C, the manner, degree, and severity of the force used, and D, the nature of the weapon, instrument, or method used. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the factors that I just listed. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killings with extreme atrocity or cruelty. A defendant may have committed the killing with extreme atrocity or cruelty even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now I want to talk about murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. 2, that the defendant A, intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy, or B, intended to cause grievous bodily harm to Cora Clancy, Dawson Clancy, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The requirements of proof for murder in the second degree are the same as for murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity. All right? And I discussed those elements earlier when I discussed the charge or the theory of first-degree murder committed with extreme atrocity or cruelty. So they're listed in that other section. All right. Now, I want to talk about manslaughter. If you find that the Commonwealth has not proven the charges of first-degree or second-degree murder, you shall consider the lesser offense of manslaughter. Now, manslaughter is an unlawful killing unintentionally caused by wanton or reckless conduct. Wanton or reckless conduct is intentional conduct that creates a high degree of likelihood that substantial harm will result to another person. An omission or failure to act may constitute wanton or reckless conduct only where the defendant has a duty to act. To prove that the defendant is guilty of manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. 1, that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. 2, that the defendant intended the conduct that caused the death of Cora, Dawson, and/or Callan Clancy. And 3, that the defendant's conduct was wanton or reckless. I'll now discuss each element in more detail. The first element is that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. As I've said before, the defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. And the third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another that a person undertakes with indifference to or disregard the consequences of such conduct. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant did not realize the grave risk of harm to another, However, the act constitutes wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized that the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that reasonably careful persons would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I've defined that term. So in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite knowledge even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. All right. So that's my instructions on the specific elements of the charges in this case. So at this point, I'm going to ask the attorneys to deliver their closing arguments. I just want to remind you, as important as they are, the closing arguments are not evidence. All right, and I'll go over that a little bit later, but I just wanted to remind you of that. And so after we go through the closing arguments, I'll come back and give you the balance of my instructions on the law. All right, and so, counsel?
Okay, we're going to start. What's up, everybody? Oh my gosh, all kinds of issues this morning, last night. I'm going to spend the rest of the day figuring it out. But here we go. Defense first. Sullivan.
About 5 weeks ago that we met like this, and I indicated to you that thank you for incredible service. That, all of us mean that sincerely. You took literally more than a month out of your lives and sat here attentively, incredible, through some of the toughest, most gut-wrenching things that any person can be subjected to. And I think I indicated that, sadly, jurors carry this trauma with them for years. And the service that you have performed, I have never seen before. You have listened to evidence. You have been fair. You have been objective. You've listened to the judge's instructions, and you've carried them into your heart, consistent with your oath, which is a very, very solemn oath. Passed between government and Lindsay, who has placed herself on her country, which country you are, as a jury of her peers. When you consider what's at stake here in the sense of what we've been dealing with, Cora, Dawson, Callan. She knows.
Wow, look at all the pictures.
And that's why we think of Cora, Dawson, Callan. For a minute. They are the victims of this case. They are the victims of the horrible, horrific act that has been laid at your feet as jurors to decide whether or not Lindsay is guilty. Beyond a reasonable doubt, as His Honor instructed you and will instruct you, what that means, that standard of proof that we as citizens in this country are so blessed to have, proof beyond a reasonable doubt before the government charges any citizen with a crime, I don't care how many cops you have in here, how many DAs are sitting here, how many people are sitting in the front row, and they're all going to sit there and be proud of this prosecution. I told you in the opening statement that this is a prosecution that has ripped the soul out of this girl. This is what they had. This is their family. How does this turn into this? How? Because of the damn medicine and the lousy medical care that she got. You can troop as many paid experts as you want to come in here and tell a jury, oh, well, she didn't say that she heard voices inside her head. She said she heard voices from outside her head. She said she was making chicken McNuggets. There was a bowl on the sofa. She wasn't making chicken McNuggets. She said something as I think and I muse and I try real hard to tell you what my opinion is, that this woman was acting in her right mind when these children were killed. So, when you consider the evidence in this case, you consider the person who is in front of you, who is the defendant, as the government refers to her, and as His Honor will likely tell you, even though a person is a defendant in a system of justice, you don't have to defend against anything. The government has the burden of proof. When the DA decides to charge someone with a crime, he has the burden of proof. His assistants have the burden of proof to prove, number one, that Lindsay is guilty of this offense beyond a reasonable doubt, and then prove, number two, that Lindsay, at the time, killed her children, was not suffering from a mental disease or defect that caused her to have a lack of substantial capacity to appreciate, to know, to realize that what was being done while she was in a psychosis. But we'll laugh
No
about
audio
that.
again?
It's just another woman. I guess it's just going to make an excuse. She's depressed. GAD, general anxiety. Give her a couple of pills, she'll be all right. You know from looking at the objective evidence in this case, this young lady, believe me, I don't have many clients like that. This young lady did nothing wrong in her life. She was a nurse, a daughter, a wife, and a darn good mother. You can see from the objective evidence, you can see, and you'll have all the exhibits for you to look at, and you can see by looking at these photographs, which you will have in the jury room. You can see the Facebook postings. You can see what she indicates about, for example, I just randomly grabbed this one, a son, my prince, that they would have you think she killed him first, cruelly, because she didn't like him. That is repulsive. So she's living her life with Pat, her kids, having a great time that summer. Life is good. She had to go back to work. In an opening statement, I told you, I said, watch the evidence. Watch the manipulation. Because that's what this case was built upon originally, and how it developed as the case progressed until it's in front of you. And how does that happen? Well, in the very beginning, going all the way back to when the first 911 call that you had to suffer through
was me. You could hear in the voice, Pat Clancy, the horror, what he had obviously experienced. You can see from the evidence that's before you the injuries that she suffered. You will have in the jury room the exhibits that indicated the extent of the injuries from, I don't have to go through all of them, the extent of the injuries to slitting her throat, to slashing her wrists, throwing herself out a window, blood all over the bedroom floor, window open, screen slashed. Oh no, the screen wasn't slashed, my bad. That's what she thought. It's called a delusion. She was in a psychosis when she thought that. Probably right here, sitting here, believes that she slashed the screen. She didn't. It's objective evidence. And why did we spend almost a week showing you the extent and the severity of that suicide attempt? The reason that we had to do that is because they were arguing that it was a fake suicide. Dinky little cuts, no bleeding. She didn't mean to kill herself. She's going to throw herself out the window, I guess, and slide down the house. Remember that one hanging off of the window? Sliding down the house, and Lindsay screwed up. And she hurt herself bad. You know that's not what happened. You know that she made, the testimony of Dr. Velkovich, that she made a very, very significant suicide effort, slashing her wrist, slitting her throat. And isn't it interesting when you consider objective evidence? Googling slitting a throat. Googling suicide. Googling drugs. Googling side effects. Googling.
I'm gonna restart it again. I'm gonna make like a couple of changes and then restart it again. The only thing is like I'm kind of thinking like I don't know if I should just end the stream because to kind of like continue to like with the endless, ending coming back, people that are I can't even rewatch the shit, it's just this constant disconnecting, reconnecting. I'll come back if you guys want me to try. I'll leave the stream up. I'm just gonna make 2 or 3 changes, restart the computer, and come back. If you want to wait, if not, I understand. It's crazy. I don't even know what the. And I thought it was my audio device. I actually, what I'm realizing, it's actually my I think it's OBS or Windows. Something's wrong because in my headphones, it's hooked up directly to the audio device, so I hear directly from the audio device, and on my end, everything's perfect, the audio. So it's not the audio device is going into Windows, and then something else is happening when it goes in there. I don't know what it is, So, yeah, let me do that. Okay.
You've got a compressed period of time that Patrick leaves to go to the restaurant to pick up the CV, and you heard the guy yesterday say, and then she sent him off to go to CVS. It's on the way. She didn't want him out of the house long. She was in distress. She wanted him home to help with the bathing, to help with the kids, to help putting them to bed. How long is he going to be gone? She Googles it. Is that something that is so nefarious? You think that goes right along the line with the book about good mothers having bad thoughts. My God, she actually Googled the time frame that Patrick would take to go to 3B and pick up the food and then leave and stop at CVS on the way. So I guess the government is suggesting she's not in a psychosis. So she's Googling Miralax because the doctor earlier that day told her that the baby Cora needed Miralax. Why would she do that? Because remember the government's opening when they told you
She wasn't suffering from the psychosis. She was a woman that didn't want to live her life anymore, wasn't happy being a mother, didn't want to live that life. So she's going to kill her kids and hopefully throw herself out the window and not paralyze herself, and then she could run off into the sunset, I guess. That's what their theory was, along with the fact that it wasn't a real good suicide, it was fake. Well, now we know, don't we? The mess that this young lady was in her brain, my brain is being damaged. I will never be better. That's the evidence. That's the evidence that we have in this case. Burden of proof is on them to prove to you that at the time that she killed these 3 beautiful kids, that she just wanted to move on with her life. And I suggest to you, just as there's no chicken nugget residue, and then when you look at those photographs, there's a slice of a cucumber, there's a slice of a carrot, there's no chicken nuggets in that bowl. Patrick wouldn't know what the kids were eating. She was the one that would cook their dinner. She was in the refrigerator, but the guy yesterday is like, oh no. Patrick said that the child was eating the chicken McNuggets in the bowl. No, she was getting food out for the 2 kids, not the little baby, 2 kids for dinner. There's no evidence that she's lying. There's no evidence that she's malingering. And finally, you remember there was a big deal about whether or not the voices are within the head. Dr. Resnick's article with the largest research on voices and malingering in the world indicates that 38% of almost 1,000 people that were examined report voices from inside their head, and it stops. You're going to buy that guy yesterday? He doesn't know what he's talking about. This young lady is not guilty of the killing of her children because she was suffering from a disease and defect, as His Honor instructed you. And they're not going to be able to prove otherwise. And it's their burden, not ours. Thank you.
Okay. The prosecution. I need some water. Prosecution. I mean, sorry, defense.
All right, come on.
There's no dispute that Lindsay Clancy was suffering from mental illness and that she tried to kill herself. There's no dispute about that. All of the evidence that you've heard, even the experts that the Commonwealth put before you, say that she was suffering from mental illness and she tried to kill herself. That's not the issue in this trial. The issue is whether, at the time she killed Cora, Dawson, and Callan, she knew the difference between right and wrong, and whether she could conform her behavior to the requirements of the law. This case is not about our mental health system or how it treats women or what's in the DSM-5 and what's not. That's a distraction to get you angry and passionate about an important issue, but an issue that's not on trial here. What's on trial here, what the issue is here, is what Lindsay Clancy did the night of January 24th, 2023, and what her mental state was at the time. And you can use her psychological history and records, the treatment records, to look at both before and after she killed the kids, to look at how she got to that point, what her thought process was, what her motivation was. But it's not the system or the DSM or any of that that caused her to strangle her kids. In fact, she had more access to treatment and care and support than a lot of people do. She had health insurance that covered multiple doctors, multiple specialty programs, treatment at South Shore, at Mass General, her stay at McLean. She had prescription coverage to cover the different trials she went through. She had support at home. She had 18 weeks of maternity leave with the opportunity to extend that as much as she needed, which is excellent, which is what all women should have. But she had that. She had support from both sides of her family, hers and Patrick's. The two older kids, Cora and Dawson, were in preschool 3.5 days a week. And she had the nanny, Elaine, who helped with Callan 3 mornings a week. And she also helped her with housework and with food prep. This wasn't a woman suffering from a lack of care, a lack of resources. She had an abundance of help, an abundance of care. She had all of that and more. And, you know, this doesn't mean that she wasn't struggling, that she wasn't dealing with mental health issues. She was. She had depression. And whether that's from bipolar or major depressive disorder or postpartum depression, it all boils down to she was depressed, right? And she was trying to deal with that, trying to get help for that. But it wasn't the fault of the providers that she was struggling with this or that she wasn't getting better. They were doing the best they could. You have the records, you heard the testimony. They were doing the best they could with the information she provided them. And that wasn't always accurate information. That wasn't always the full picture. And they were doing the best they could with her level of cooperation and compliance with the plan. Take her medications. You know from the records and from the pill bottles what she was prescribed and how she was supposed to take those medications. And you know from the pill bottles what she actually took. And sometimes those two things didn't align with what she told her providers, what she told Patrick, what she told her mother. You take the Zoloft, for example. The prescription was for 1 25 milligram pill a day for 7 days, and then to go up to the 50 milligrams after 7 days. She told Dr. Tufts that she took the pills as prescribed for 7 days, went up on the 8th day to 50 milligrams, and that's when she had the insomnia and the other side effects and symptoms. She told Patrick that she took the pills for 7 days and they had no effect, so she called Dr. Tufts, who then told her to increase the dose. Well, you know what she told Patrick is not accurate because the pill bottle says, take it for a week and then increase it. That was the plan from the beginning. That wasn't the result of a phone call to Dr. Tufts. And you know what she told Dr. Tufts isn't accurate either because only 7 pills were taken from the bottle. So that leaves you 2 options. Either she took the medication as prescribed, 1 pill a day for 7 days, and then didn't increase it, which she says is what caused the side effects and the insomnia, or what she did was not take it as prescribed. She didn't do it 7 days and ease into it and then increase it. She either missed a dose or increased it early before she was supposed to. Either scenario is not good. She knows as a nurse the importance of following the instructions of your medications. She knows how important it is to follow the plan and do what's on the bottle and do what your provider tells you and to give that accurate information to your provider. She didn't say, I went up to 50 too early. Maybe they could have adjusted that and tried the 25 milligram for longer and eased her into it. But no, she told her that she did what she was told and then went up and had these problems. So you can see that in a lot of the medication she has. You have the pill bottles that were turned in by Patrick, and a lot of them don't even have many pills missing from the bottles. Some of them have none. The Buspar prescription, the first one, there's only 2 pills missing. The second prescription, no pills missing. The Lamictal, she never took those pills at all until the night she tried to kill herself. So there's a lack of compliance there, a lack of follow-through, a lack of communication with her providers about what was happening with her and how she was taking the medications. And defense wants you to believe that this is a woman who's begging for help and willing to do anything and everything her providers tell her to do to get better. And she was asking for help. She wanted help. She wanted to get better. But she wanted to get better on her own terms, doing things her way, the way she thought she should do them. And as a nurse, she knew that's not the right way to approach it. She knew that an accurate medical history, accurate information about your side effects and symptoms, what your thoughts are, that's important for your providers to know. And she didn't do it. And it seems that the reason that she's not necessarily fully compliant and she's doing what she wants to do is she has this desire to be herself again. She just wants to go back to who she was, and she wants it now. And she doesn't want any side effects. She just wants to be herself again and wants it now. And that's understandable. That's relatable, to want to get that magic pill that will fix you immediately and you can go back to being yourself. But she knew that's not how it worked. And you know that's what she was thinking, because in the searches on her phone, she's searching for things like, which antidepressant works the fastest? How fast does Wellbutrin work? And she's searching all of these different medications for the side effects and symptoms, some of them that she never even discusses with her doctors. And, you know, again, it's relatable that she wants to get back to where she was, but she had discussions with her providers about how these medications work, and that it takes time for them to get into your system, and it takes time for them to work. She even texted her mother about that, about how she knew that she had to be patient, that it took the amitriptyline, for example, to get into her system and worked. And she knew all of this, and she couldn't be patient. She couldn't wait. She wanted faster. She even told Dr. Tufts, it's a note in the records, that she knew the problem was that she wasn't focusing on one provider and following one plan. She knew that going from doctor to doctor, practice to practice, South Shore to MGH, to different programs, not the best way to deal with the situation. She said it in her own words to Dr. Tufts, you need to stick with one provider and stick with one plan to see if it works. And she actually turned down help from at least 2 locations at various points. We talked a lot about the women and infants records, and you know, you don't have to believe what I say about them or the witnesses say about them or defense. You can look at the records themselves. Page 9, it says right there, Patrick was the one who said over-medication was the issue. Not the doctors there, not the people evaluating her. What they put was depression, RO, rule out adverse medication effects. That means they have to look into it to see if medication's a problem. But there's a difference between an adverse effect, a symptom, or a problem with a medication, and being over-medicated, taking too much of a medication or taking too many at one time. There's a difference there. And women and infants never said she was over-medicated. What they also don't do is turn her away. It's not that she went there and they said, can't help you, go away. They told her, it's in the records, based on the onset of her symptoms, they weren't sure if it was postpartum or peripartum. They saw she had an issue. They wanted to help her. It says there, we offered her. They offered her 3 programs. They offered her the inpatient medical management program. They offered her a partial hospitalization program for general mental health. And they offered her an outpatient program. It shows they put a lot of thought into that, into offering her this care. When they gave her 3 separate options, considering she's a young mom, maybe she doesn't want to be away from home, but we'll give her the option of being in the hospital and getting her medications right. But we'll also give her the option of the partial hospitalization, where she can, be here during the day and go home to her kids in the evening. And then that third option of being an outpatient and being able to be at home with her kids and come in for appointments. It was very thoughtful of them. It was very well planned out to give her these 3 options. And it's kind of the exact opposite of just turning someone away and saying, go away, we can't help you. And her response, well, I'm going to talk to my provider about it for guidance. And she goes to Dr. Tufts. She sees Gelada at some point. You look at the records, she never discussed those options with them. She told them that women and infants turned her away and said she didn't qualify for the program. She didn't discuss those 3 programs that they offered her. So basically, they give her this offer of help, 3 different forms of help, and she says, no, doesn't want to do them, and doesn't discuss it with her provider. And also that first time she goes to Mass General, to the emergency room, they offer her a bed at McLean, and she turns it down. She wants help. No one's saying she doesn't want help, But she's making these decisions and doing these things that aren't helping her get help, that are turning away help, because she wants the help in a certain way, in a certain time frame. And, all during this time, between September and December of 2022, she's interacting with friends, with family, teachers, gym staff, the nanny, people at gymnastics, interacting with them in public spaces, in public ways, driving her kids around, all throughout that time, able to know the difference between right and wrong, able to conform her behavior to the law and to the requirements of society, and interacting with others and presenting herself as a functioning adult, a functioning mom. You know that she knew the difference between right and wrong during that time because she had those thoughts at the beginning of December of harming her kids. And she told Patrick and her mother about them. But who she didn't tell is important and very telling. She didn't tell a single provider, not Tufts, not Gelada, not Jennifer McAllister, not Dukes, no one at McLean, no one at MGH, no one at South Shore. Didn't tell any of them. And why? Because the police might take away her kids. That's a rational thought. That telling mandated reporters that you're having a thought of harming your kids, that they might be taken away for their safety, that's a rational thought. And it also shows she knew it was a bad thought, a wrong thought. Because you don't think someone's going to take your kids away because you're thinking something positive or neutral. It's because it's bad, it's because it's wrong, it's because it's against the law. So she knew that it was wrong. And she was able to conform her behavior to the law because she didn't tell those providers. She went in and met with them and talked about what she was experiencing and talked about her depression. And not only did she not tell them, she lied to them. They asked her, are you having thoughts of harming others? Do you have homicidal ideation? She told Tufts no. She told Gelada no. She told Dukes no. She told Goodhart no. Every day at McLean, she said no. At MGH, she said no. So not only is she hiding it, she's lying about it. She's controlling her behavior. She's controlling the presentation she presents to her providers. And then we get to her being admitted to McLean. You know, up to that point, all of the drugs she's taken from September through December, they weren't given at the same time. The most she ever had at one time was 2 to 3 medications. And usually if it was 3, that third medication was the Benadryl or the hydroxyzine that's like Benadryl, or the Ativan or Valium as needed for anxiety. But most of the time it was 2 medications. And the way they did those medications, you heard from Dr. Satoff, a man who's examined thousands of patients with psychosis, who's treated women with postpartum psychosis, who's treated women who have killed their children, that man who apparently has no expertise. You heard from him that the medication trials were reasonable and rational. She tried a medication, it didn't work, or they had side effects, they stopped the medication. They tried something else. They tried a different combination. And unfortunately, with mental health, there's no blood test or CAT scan or MRI that you can do that says, well, you have bipolar or you have schizophrenia. It unfortunately doesn't work like that. So what the providers have to do is rely on what the patient's telling them. Hope that information is accurate. Rely on what they're observing about the patient and make a diagnosis. And then based on that diagnosis, have a treatment plan. And every patient reacts differently to medication. One patient could do fine on it, the next not. So they have to do that trial and error process, and it's normal, it's typical, it's reasonable. And that's what they did for her. And even if you believe that the number of different medications she took over that time or the combination of those medications affected her negatively, after McLean, they were out of her system. Some of them had been out of her system for months. Zoloft she stopped in October. Other pills she stopped in November or December. And that last one, the Seroquel, that she really had a bad reaction to, is out of her system. The only medication she's on leaving McLean is trazodone for sleep and Valium for anxiety. And that's it when she leaves there. And why does she leave there? He wants to go to Cora's birthday party. And that's relatable, that's understandable. She wants to be that mom again who can throw her daughter a party and enjoy it. It's completely understandable why she would want to leave, but she also knew she wasn't there. She knew how she was feeling. She knew she was depressed. She knew she needed help. But she wanted to be that mom she was more. And there was nothing McLean could do to keep her there. She said she denied suicidal ideation. She denied homicidal ideation. She said she wasn't hearing voices or seeing anything. They saw the entire time she was there no signs of psychosis. In fact, every doctor she saw, from Tufts in September all the way through Tufts at January 23rd, none of them saw any signs of psychosis ever. So they're all wrong. All these different doctors at all these different practices, they're all collectively together wrong. That doesn't make sense. But she shows when she's leaving McLean, no signs of psychosis. And they even give her a task to do to see if she can manage her mental health outside of the hospital. Make an appointment, pick a doctor, make an appointment. And she does it. She decides on Dr. Tufts. She makes the follow-up appointment. She gets the documentation and gives it to them, showing she can manage her mental health. They have to let her go at that point. She's there voluntarily. There's no grounds to keep her if she's not showing she's a danger to herself or others. So they let her go home. And at home, again, all throughout January, she's showing her ability to know right from wrong and to conform her behavior to the requirements of the law in all the activities she does in January. First, there's the birthday party. She's throwing the birthday party. She's monitoring the kids, making sure, typical mom birthday party stuff. Everyone's eating, getting cake, singing happy birthday. You saw her in the video. She appeared happy and smiling, normal. Everyone that interacted with her said, seemed a little tired, but okay. The Museum of Science. You have that video. The Museum of Science in Boston can be crowded and overwhelming on a good day. And she's there with 3 kids under 5 with her husband. You see her monitoring them, caring for them, doing the exhibits, showing them what to do with the exhibits. If you watched that video and you didn't know who the Clancy family was, and we asked you, pick out the woman who is depressed, pick out the woman who wants to kill herself, pick out the woman who's about to kill her kids, you couldn't pick her out. She's completely calm. All her behaviors are typical and normal because she's able to control her behavior. She's able to be suicidal and feel those things, but control her behavior, control her thoughts, and present that image to the world. She's able to do it at the Cape Codder as well. Similar scenario. She's able to watch the kids when Patrick goes to brunch. She's able to watch the boys when Patrick and Cora go skiing on the 16th. She's able to interact with the Carneys on January 22nd. And yeah, they both initially said she was quiet, but then they both admitted she was always kind of quiet. But she was able to interact with them, chat with them in the kitchen. Seemed okay. In between January 7th and January 21st, her mother never comes to the house to intervene. Her sister, a licensed social worker, a mandated reporter, never comes to the house to intervene or help, never makes a report. And they're in contact with her every day, texting with her, calling with her almost every day, and never see any signs that they should be concerned or worried or intervene. And you have those text messages between the defendant and her mom. And her mom, obviously, was very attentive, very caring, asked very pointed questions. How are you doing? How are you sleeping? How are the medications? obviously a very concerned mom. How did Lindsay answer? I'm getting a little better. I'm sleeping better. She said the only time her sleep was interrupted is if Cora had a bellyache or one of the kids was up. But she's doing better every day. She's sleeping better. She's feeling better. She still says, I'm not myself. I'm not where I want to be, but she's moving in the right direction. And we have that text from her mom the day she leaves on the 22nd, headed back home. I'm glad to see you're doing so much better. Now her mom now wants you to believe that she lied to her, that she wasn't doing better and she was just trying to encourage her. But there are so many things you can say to your daughter who's struggling with mental health other than lie to her if you want to encourage her. You know, you've got this. Take it day by day. I'm here for you. We're going to get through this. But she wants you to think she lied to her when she said she was doing better. But you know that wasn't a lie. You know that she was doing better, or seemed to be, and that her mom said, I'm glad you're doing so much better, because Patrick said the same thing. He said she was doing better in January. Every day was better. The 24th was the best day. They had hope, because that's what she wanted to show them. The only person during that time that she gave even a little glimpse of maybe she wasn't doing that much better was Dr. Tufts. And she told Dr. Tufts that she was feeling depressed, which is why Dr. Tufts prescribed the 10 milligrams of amitriptyline a day. Very low dose. And then she told Dr. Tufts again, still not helping. And so Dr. Tufts raised it to the 20 milligrams. Again, a very low dose, a dose a child could take. And that shows how cautious and conservative Dr. Tufts was being in the treatment of this patient who had had those interactions with medications previously. She was being cautious and conservative and acting with care for the patient by slowly increasing the medication. But even with Dr. Tufts, she still denied having a suicide plan, denied wanting to hurt anyone else, denied voices, denied visual hallucinations, showed no signs of psychosis. All the way up to January 23rd, nothing. And if you look at their journal, you look at this journal that defense counsel showed you, she's very detailed, excuse me, about when she took medication, what she took, the amounts she took, what the effect was for months, starting in October and going all the way up to January. And where it stops, January 18th. Someone who's been so meticulous about everything all the way up to January 18th, and it just stops. It's as if she's decided she's done trying. She's decided that it's too much and she doesn't want to do it anymore. And so she just stops keeping track of the prescriptions. And then we get to January 24th. Everything that happened that day, every person she interacted with, every situation she was in, shows you she knew the difference between right and wrong, and she could conform her behavior to the law. The doctor's appointment first thing in the morning. She's able to drive there. She's able to interact with medical professionals. She's able to seem absolutely fine and normal. And this is a doctor who's treated the kids since Cora was a baby. This is a pediatrician who's known the family and has known Lindsay for almost 5 years. A woman who's trained in recognizing the signs of postpartum depression. She told you she looks for flat affect, she looks for teariness and some other things that she told you. She saw none of that. She was able to control herself and interact with her in a perfectly normal, concerned mother way. Able to get home from that appointment. She plays with the kids, she takes them outside, she's sending those messages and photos to her mom and to Patrick, basically saying, look, this is a good day. I'm having a good day. Everything's good. I'm getting better. Here's proof. This is what I'm doing. You start to see the planning at about 4 o'clock in the afternoon. and this is on her phone, you can see her search for Miralax, kids Miralax at 4:02. And then a little while later at 4:13, you see her search for takeout from 3V. And then immediately after, she does the Apple Maps search to see how long it takes to get to 3V. Well, defense wants you to believe that, she was checking that because she didn't want him gone for too long. She wanted him home. She was in distress. If you're in distress, don't send him anywhere. Make food at home, have him cook, get delivery, get DoorDash. Go to one of the other restaurants that Patrick mentioned that were 2 minutes down the road. And she didn't have to look up on Apple Maps to see where this restaurant was. You heard from Patrick, they had been there at least 3 times in the months before. She had lived in that area for 4 years. She knew where it was. She knew generally how long it would take to get there. What she needed to know was how long specifically on that night it would take to get there. Because she knew she would have a limited amount of time to do what she wanted to do. And what she had decided to do was to kill the children and then kill herself. And so she needed to know, not generally, but exactly how much time will I have. And then obviously sees that that's not enough time. So then she searches CVS. And not only does she search CVS, she calls them. Calls them and asks them if they have kids Miralax, and they say no, but they have Pedialax and one other medication. And then she asks, is it in stock? Because she needs to know not only what they have, but is it in stock? Because she's adding to this errand that she's sending Patrick out on. And she has to make sure she's not interrupted. She doesn't want that call at 5:33. She wants him to go to CVS and have the medication there and get it and then go on to 3V so she has time to do what she needs to do. So that's why she's calling to see what they have and make sure it's in stock. It's a level of planning there and thinking and decision making that Dr. Satoff referenced. And then after that, she texts Patrick, it's been a long day, can we do 3V? And he's on board with that. And she's like, okay, check out the menu, let's get on this. And he asks her what she's getting. She tells him the Mediterranean Power Bowl. He says he's getting the pork belly risotto. 5:10 p.m., she's calling that order in. She's talking to the hostess. She gets the order accurate. She is able to answer questions about how she wants her food. She's able to recall and give Patrick's phone number and his name as the person picking up. And then Patrick's leaving to go get the food. And as he's leaving, the kids are in the living room on the couch eating. The defendant's in the doorway near the basement door. And she says to him, oh, by the way, can you go to CVS? Acting like it's this last minute thought, like, oh, by the way, can you get this? And not something that she's been planning for over an hour. She knew about the Pedialax and she knew about 3V and she knew all of that before she even asked him about dinner. But it's like, oh, can you go to CVS on your way and get kids Pedialax? And he, of course, is like, sure, I'll get that. And he heads out the door at 5:15. And that's the time he leaves because he says to her, yeah, just text it to me. And that's such a normal kind of interaction that we have in your common sense and life experience. You're headed out the door to run an errand and someone in your home says, oh, while you're out, could you get me X, Y, and Z? And you're like, yeah, sure, just text it to me. Because you don't want to get there and be like, oh, what did they want me to get? It's such a normal interaction, right? Can you get this for me? Sure, text it to me. And he heads out the door and she texts it to him at 5:15 p.m. And then he goes to CVS. Even though she's told him what to get and they have it, he still makes that call at 5:33. She calls him back at 5:34. And then he heads out to 3V and then comes home. And when he gets home, puts the things on the counter and it's quiet. It's quiet in a way that a house with 3 kids under 5 should not be during waking hours. So he calls out to them, no answer. He goes to the basement door and opens it and yells down and no answer. and he closes the door. He calls her phone, no answer. He goes upstairs and is able to unlock the door and see the blood and see the window open and go down to her. And when he goes down to her, she's no longer actively bleeding. He doesn't have to put pressure on any of her wounds. And he says to her, "What did you do?" And her response is, "I tried to kill myself." And then it's, "Where are the kids?" In the basement. It's not, "I heard a voice. I was compelled to do this. I didn't want to do this. Go help the kids. They're hurt. They're in the basement. Go save them." No. It's, "I tried to kill myself, and the kids are in the basement." And defense wants you to believe that conversation couldn't have happened because of how she sounded on the 911 call. But you heard from the doctors, people can deteriorate over time. When he first gets there, she's able to talk to him. And as that progresses, she's losing the ability to talk. And there's nothing in the medical records about her throat being crushed or her thyroid being crushed. You can look at that. Her thyroid was bruised, her vertebrae were broken, but her throat wasn't crushed. She had the ability to make sound and to communicate. And if you listen to the 911, he's talking to her, and then he's answering the 911 dispatchers about what she said. So even if we can't hear her clearly and we can't understand what she was saying, he could. You know from all of the evidence that you have, putting aside the experts, but all the evidence you have in terms of crime scene photos and videos and the witness testimony and all the medical records, you know how she killed them, where she killed them, what time she killed them, and the order that she killed them in. Even without what she told the doctors about the order, that's something you can infer from the evidence. Because you know, in order to bring the kids to the basement and strangle each one of them, and then come upstairs and get a knife and have a phone call, and then go upstairs to the second floor and either take handfuls of pills or crush them, however she did it, take the pills, and then cut herself. And it's not just 3 cuts, it's the hesitation marks, and then the cuts themselves. And then you know she bled in a couple spots for a little while, because you heard from Sherry Crook how the pooling in front of the mirror is someone, basically the blood dropping down and someone there for a period of time. And then over closer to the window, the same thing. So she's bleeding in front of the mirror for a period of time, over by the window for a period of time, and then she goes out of the window. And whether she dove out or climbed out and slid down, whatever you think that evidence shows from the shingles and everything you've seen, whatever happened, she goes out of the window and she's on the ground. And by the time Patrick gets there, she's no longer bleeding. So for all of that to happen in that short amount of time while Patrick's gone, she had to have started killing the kids immediately after he left. Now, defense wants you to believe that it was after the phone call.
Damn.
That after the phone call, she heard the voice and killed the children. But there's a few things about that don't make sense. First is what she told Dr. Satoff, that when she gets the call, she's at the fridge getting chicken nuggets out of the fridge to make dinner. You heard from Patrick, when he's leaving, Dawson is sitting on the couch eating chicken nuggets and green beans out of a bowl. There's the crime scene photo of 2 bowls on the couch. Yes, the pink one seems to have some vegetables in it, but there's the blue one there as well. And Patrick saw Dawson eating the chicken nuggets and green beans. So why would the defendant make that up? Why would she say she's doing that during the phone call? Because if she's already killed the kids because of a voice and being compelled and it being against her will and she's like a puppet, then she can't get a call and miss it and then call the person back and have a conversation and then hang up. A puppet can't do those things. Those are decisions and choices and actions that she's controlling. So she has to explain away the phone call because her behavior and her ability to have the phone call don't make sense. if she's being compelled by her voice, if she's not in control. And you, further on that, you have the phone. You have the flights climbed. There were 2 flights climbed. You can see, you have Ian Whiffin's report. You can see there were 2 flights climbed. The first ends at 5:33. So it makes sense that she has killed the kids in the basement and she has come up the stairs, and at 5:33, she's in the kitchen and she's getting the knife. And then Patrick calls. Everything she's done, everything from the research to making sure what they have, to telling him to get it, to making sure it's on stock, all of that, and he still calls her, he still interrupts her. And then she gets the knife and she goes upstairs, and she's at the top of the stairs by 5:38. So the phone calls from 5:33 to just before 5:35. So if you want to believe that the voice happened after the call, and the killing of the kids happened after the call, between 5:33 and 5:38, she doesn't go down and come back up and come back up and come back up. There's nothing on that phone about that. And there wouldn't be enough time for her to bring those kids down to the basement and strangle each one in 3 minutes. You heard from the doctors, and Dr. Lapisato included, it could take up to 30 seconds for each child to go unconscious. And then strangulation would have to continue for another 1 to 2 minutes to cause death. And Dr. Lapisato wanted you to believe that the band could just stay there around their necks by themselves. But you have the bands. They're exercise bands. You pull them, they resist, you let go, they snap back. I had to hold them up to show her in circles like around someone's neck. And when I let go, they expanded. They don't stay around someone's neck on their own. You have to pull them. And you know they weren't knotted. Patrick never testified that they were knotted, so I'll take this one. He testified that he didn't have a clear memory, but he remembered that they were possibly looped. And I asked him, like, when you're tying your shoe, that first loop before you do a bow? And he said, yeah, kind of like that. So not knotted, not tied, but even his memory wasn't the best. You heard him on that call. And that's why we had to play the call for you, because you could hear him. You could hear when he found each kid. And you knew that he had the phone with him when he found each kid, because his voice, it never sounded like he was in another room. It always sounded so painfully right there. And so you know he's holding the phone and he's not untying knots. And he wouldn't have had the time to untie knots in that short amount of time. And then you have the firefighters looking in the window, seeing him with Dawson. And he's not untying a knot or unlooping something. They say they see him in an unwinding motion, unwrapping. That's why you had to listen to the 911, to show that she did stand over their limp bodies and strangle them for 1 to 2 minutes after they went unconscious. Because those weren't knotted. They weren't tied. They don't just stay there on their own. And even if you wanted to believe that at 5:38, she goes upstairs and puts the phone on the bed, and then she goes down and kills the kids, and she does everything. 5:38 to just after 6 p.m., because he's making the call to her at 6:09. There's not enough time between 5:38 and just after 6 p.m. to kill all 3 kids, to get the knife, to take the pills, to cut herself, to bleed, to go out of the window, to stop bleeding, and Patrick to get there. In 20-odd minutes, it's not enough time. So you know she killed those kids as soon as he left. And when she got the call from him, she had already strangled them. And she didn't tell him. She didn't ask for help. She didn't say, oh my God, what have I done? She's a nurse. She didn't go down and try to do CPR and help them. No, she lied. She stayed calm. She presented herself as normal. She had complete control over her behavior and her emotions. She had a normal conversation with him because she didn't want him coming home, because she needed to finish her plan. She still had to kill herself. So why did she do it? Defense would have you believe that a mother who was this good, who loved her kids this much, which we're not denying, would never harm her kids this way unless she was so mentally ill that she was hearing these command voices and had no choice. But that's not the world we live in. Dr. Resnick told you, most women who kill their children do it in child abuse. Most women who kill their children don't do it because of mental illness. Mothers kill their children, and it's horrible and it's awful, but it happens. So why did she specifically do it? She was depressed. She was exhausted. She was done. She didn't want to try anymore. She felt damaged. But those kids were her protective factor. Those kids were keeping her from ending her misery. And so she had to remove the protective factor. And I'm not saying she was happy about it. I'm saying that it was what she had to do to end her misery. But it was a choice. It was a choice. She could have kept trying. She could have, moved down to her mother's. She could have killed herself and left her kids alive. But it was a choice to take them with her. It was a horrible choice. And it's a choice that we don't want to think about that a mother could make, because that doesn't make us feel safe or comfortable in this world. But it's a choice she made. She knew it was wrong because she sent Patrick out to do it. She could conform her behavior because she waited until he was gone and didn't tell him what was going on those phone calls, didn't call 911 for help, didn't lock herself in a bathroom upon hearing this voice. She knew it was wrong. She didn't take advantage of this situation. She created this situation, this opportunity to do what she wanted. And when she woke in the hospital, and she knew she was alive and the kids weren't, she knew what she did was wrong. She said she felt horrified. And then, while still with a tube in her throat, she's asking, do I have a lawyer? And it's not what defense said. It was after surgery and she's delirious. Look at the records. She had surgery on the 27th. She's asking if she has a lawyer on the 26th. Do I have a lawyer? Because she knows what she did was wrong. And then we get the justification, the excuse of the voice. And there are a few reasons why the voice doesn't make sense. The first is she immediately obeyed it. Dr. Resnick, their expert, the one who knows everything about postpartum psychosis, he teaches other psychiatrists and psychologists. He writes books and chapters and articles about how this is a huge red flag if someone immediately obeys a voice. You heard him talk about Andrea Yates, about how she heard voices to kill her children for months. And what did she do? She committed herself 5 times. She tried to kill herself twice to avoid harming her children. Counsel, that was all accurate.
Let's move on from that.
Lindsay Clancy hears his voice one time and does it. Doesn't try to lock herself in the bathroom, call Patrick, call 911. Doesn't try to leave. Leaving little children alone for 20, 30 minutes, not the greatest option, but it's better than killing them. She doesn't try any tactics to avoid the voice. She just obeys. Another red flag that Resnick was asked about and teaches and writes about is that she only heard the voice one time. She never heard it before, and she hasn't heard it since. So how that works. It's a red flag that she's making up the voice. Another one is that what she said the voice told her isn't consistent. At the hospital, she says the voice said, you have to kill your children so you can kill yourself because they'll suffer without you. What she tells a lot of the doctors is, it says, this is your last chance, you have to kill the kids so you can kill yourself. And then she tells the chaplain, a third version, you have to kill the kids so you can kill yourself because they're in danger. There's these three different versions. Another flag red flag, it doesn't make sense. That the voice, she's saying the voice says all these different things. And then the fourth thing that doesn't make sense about the voice is that it's vague in its command. It doesn't tell her how to kill the kids, where, with what, nothing. It says kill the kids so you can kill yourself. So she had to choose where, the basement. She had to choose how, strangulation. She had to choose with what, exercise ban. Choose again, exercise ban. Choose again, exercise ban. She had to choose how to kill herself. Now, if you're being compelled by this voice, and you have no free will whatsoever, you're just your body's acting on the voice, why wouldn't you just kill yourself the same way you killed the children? You strangled them, you hang yourself.
Oh.
That's acting on compulsion, that's no choice. She tried 3 different ways. And none of them similar to what happened to the kids. And I'll take this other quarter now and explain to you why we got into the superficiality of the wounds and why we got into the height of the window and why we got into how she didn't take enough pills to actually kill herself. We're not saying she didn't want to kill herself. We're talking about that third prong of suicidality that Dr. Sattoff talked about. Remember, he talked about aloneness and feeling burdensome, but that third category, capability. She wanted to kill herself, but her natural instinct to live was fighting against that. So she took pills, but you heard the toxicologists, they were all at therapeutic levels or below, except the Seroquel, which was a little elevated. She cut herself, but you saw the cuts on the meaty part of her arm horizontally. No arteries, no major blood vessels. Didn't need to be stitched the next day. The one on her neck didn't need to be stitched at all. She knew as a nurse those weren't going to kill her, but she was trying. And then going out of the window, 12, 13 feet. And she landed the wrong way and ended up paralyzed on the frozen ground. But, you know, the idea that falling out of a 12-foot window is going to definitely kill you, not necessarily. And so she wanted to. She was trying in all these different ways. But she just couldn't get over that third prong, the capability of actually killing herself. And that goes against it being a voice. Because if she's compelled to do it, if this voice is making her do it, she would just do it. There would be no fight. There would be no struggle. There would be no resistance to dying. But there was. I guess the third one is Dr. Zeisel. We've never said that he told the defendant what to say. Not one witness, not one piece of evidence. The only person that said that Dr. Zeisel, that we were trying to say Dr. Zeisel told her to make up the voice, is defense counsel. He's the only one that asked about it. He's the only one that brought it up. We have never said that in this courtroom, and no witness has said that we've asked. She knew what she did was wrong. She could conform her behavior to the law and chose not to. And she didn't expect to have any consequences because she expected to die with her children. And we get to what we have to prove is that first degree is deliberate premeditation and extreme atrocity and cruelty. You know it was deliberate premeditation because of the way she killed them and the way they died.
Yeah, the three of them. Not at one time. Not at one point
And
when
the
she was killing
order
three of them.
also
Did it cross her
showed
mind to stop?
rationality. The order she killed them in. Because Cora and Dawson are older. If she had tried to strangle one in front of the other, they would have known this is bad. And they would have tried to intervene or run and hide. And she had a very limited time. She didn't have time to try to find a child who ran off and hid. So taking Dawson first and moving him to a separate room, having Cora stay with Callan and having Dawson go in another room.
I didn't know she did all that. She moved them to separate rooms. I thought she did all that like next to each other. Wow.
That's rational. That makes sense. That's ordered thinking.
Guilty.
We didn't show you that post that she made about Dawson being a handful and not being compliant to show she was a bad mom. We showed it to you because it proves she knew that he was a handful. She knew that he was less likely to be compliant, to just go along. She knew that he might struggle. And so it made sense rationally to remove him and separate him first and kill him first. And she brought him into that room, into the office, and closed the door, and she wrapped that band around his little neck. And she squeezed until he was unconscious. As the blood's pooling in his face and causing those blood vessels to burst, causing him pain and panic and confusion. And defense calls Dr. La Posada to say, no, it wasn't 20 or 30 seconds. It was only 5 or 10 seconds until he went unconscious. I'm sorry, how many seconds is it okay for them to have been in pain and panic and confusion?
Yeah, that's horrible.
How about it wasn't okay for 1 second for any of those children to feel that? And they all felt it, all for up to 30 seconds. And then she continued strangling their limp bodies for 1 to 2 minutes to make sure they were dead. Deliberate premeditation. And then extreme atrocity and cruelty. The indifference that she showed to their pain, to their struggle, to their suffering, leaving them there on the floor with the bands around their necks, completely indifferent, because she had a plan and she was following it through. Just think of that. The being strangled and the pain and the confusion that they're going through, and it's being done by their mom. Their mom is the one that's hurting them. Their mom is the one that's killing them. That's extreme atrocity and cruelty. She didn't see them in that moment as individual human beings with rights, with dreams, with futures, individually belonging to them. You heard about the 3 kids. Cora wanted to be a doctor and a mom. Dawson wanted to be a firefighter. Callan never got the chance to dream. Who knows what future he would have dreamed for himself. She killed them, and she left them there on the floor with the bands around their necks. She didn't bring them up to their beds and put them with their favorite stuffed animal and cover them up gently and lovingly, leaving them peacefully there. No. She left them discarded on the basement floor like broken toys because she was done playing the game. You know to a moral certainty. She is guilty.
All right, thank you, counsel. Now, members of the jury, been sitting here for a while. Does anybody need a short break? I think that would. All right. So we're going to return now to the instructions that I have. In rereading my instructions, I just kind of want to make sure that something's clear. So I'm going to ask you to go back to page 6. I think we were talking about murder in the second degree. Everybody get there.
I think they're going to do jury instructions now, I guess. No breaks. Thank you, guys. I'm sorry about all the audio issues that I had. or been having and whatever. I think it's resolved. I don't know. It's been about an hour now. I've been having this problem for actually a long time, but it was getting worse, it seemed.
And what I just kind of wanted to make clear, that you may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining any of the elements in the murder in the second-degree charge as well. I mentioned that for some of the others, but and specifically for the charge in murder of second degree, there's an element regarding intent. Okay, so I just kind of wanted to make that clear. Probably is suggested in that, but as I read through it, I just kind of wanted to remind you that you can, as I said, you can consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining the elements in murder in the second degree. All right. So I hope that cleared things up rather than confusing you any. But now I'm going to go to the general principles in regards to this case. All right. Now, as I said to you before, I'm incorporating the instructions that I gave earlier before the closing arguments with these instructions. So I want to talk about the presumption of innocence and the burden of proof. Once again, the indictments against Ms. Clancy are only an accusation. They're not evidence. The defendant has denied that she's guilty of the crimes charged in these indictments. The law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. This burden of proof never shifts. The defendant is not required to call any witnesses or produce any evidence, since she is presumed to be innocent. The presumption of innocence stays with the defendant unless and until the evidence convinces you, unanimously as a jury, that the defendant is guilty beyond a reasonable doubt. It requires you to find the defendant not guilty unless her guilt has been proved beyond a reasonable doubt. Your verdict, whether it is guilty or not guilty, must be unanimous. All right. Now, reasonable doubt. The burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against her, as I just told you. But what is proof beyond a reasonable doubt? Well, the term is often used and probably pretty well understood, though it's not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you've compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, I want to talk initially about my function of the judge. My function as a judge in this case has been to see that the trial is conducted fairly, efficiently, and in an orderly manner. It's also my responsibility to rule on what you may consider as evidence and to instruct you on the law that applies in this case. It's your duty as jurors in this case to accept the law as I stated to you. You should consider all of my instructions as a whole. You may not ignore any instruction or give special attention to any one instruction. You must follow the law as I give it to you, whether you agree with it or not. That's not just because I'm the judge. It's because every person who comes to court for trial is equal and is subject to the same law. And if jurors in each case were to apply what they thought the law should be, and the jurors in different cases had different views, then the parties in those cases would not be treated equally. The law that I'm instructing you on is the law that has been established by our legislature and our appellate courts, and it applies to everyone. And you must apply the law as I instruct you. Function of the jury. Your function is to determine the facts of this case. You are the sole and exclusive judges of the facts. You alone determine what evidence to accept, how important any evidence is that you do accept, and what conclusions to draw from all the evidence. You must apply the law as I give it to you, to the facts as you determine them to be, in order to decide whether the Commonwealth has proven its case. You should determine the facts solely on a fair consideration of the evidence. You are to be completely fair and impartial, and you are not to be swayed by prejudice, by personal likes or dislikes towards either side, or by any personal view you may have the nature of the claims or the defenses in the case. Your decisions must rest solely on the facts that you find and the law that I give to you in these instructions. Nor are you to be influenced by any personal likes or dislikes you've come to feel towards any party or any attorney. In this courtroom, every person is equal and is entitled to a fair and impartial verdict in accordance with the evidence and the law. You are not to decide this case based on anything you may have read or heard outside of this courtroom. That, with the exception of that, is the observations you made at that view, and I'll talk about that a little bit later. You are not to engage in any guesswork about any unanswered questions that remain in your mind, or to speculate about what the quote-unquote real facts might or might not have been, beyond what has been proved by the evidence. You should not consider anything that I've said or done during the trial as any indication of any opinions as to how you should decide this case. If you believe that I've expressed or hinted at any opinion about the facts of this case, please disregard it. I have no opinion about the facts or what your verdict ought to be. That is solely and exclusively your duty and your responsibility. Now, I'll talk about function of counsel. It was the duty of the lawyers in this case to object when the other side offered evidence which that lawyer believed was not admissible under our law. They also had an obligation to ask to speak to me at the sidebar about questions of law which the law requires me to rule on outside of your hearing. The purpose of such objections in rulings is not to keep relevant information from you. You should not draw any inference, favorable or unfavorable, to any attorney.
Okay, let me see. I want to check something out. So they're saying, I saw someone in the chat say somebody's live got taken down. Streaming this, and they said Surviving the Survivor. I don't know which live feed. Anybody know what live feed he was using? So I went and typed his name in, and and I clicked the link, and it got this. So I think they just stopped or disabled his stream. I don't know if he went back on or not. I didn't know they were doing that. Were they doing that for this trial? I thought people were streaming the whole trial with no problem, no? Or does it depend what feed you're using? I think they probably just booted him offline. Let me see. Surviving the Survivor. He didn't say nothing about this shit. Papa, suspended stream policy. Somebody said, how dare you bring up COVID? Did he bring up COVID? You talk about COVID? Well, for me, it's not worth it because this stream was, I had so many issues. Maybe that's why. Oh, he's back live, though. He's back live.
Redactions. No.
Oh, he's using law and crime. I don't know if he was using that before, but he's back live. I guess it just took it down. Sometimes there's like certain audio that's playing. I don't know if it was the courtroom or he played something else.
Of course, the quality or strength of the proof is not determined by the sheer volume of evidence or the number of witnesses or exhibits. It's the weight of the evidence, its strength, intending to prove the issue at stake that's important. Some things that occur during a trial are not evidence, and you may not consider them as evidence in deciding the facts of this case. A question put to a witness is never evidence. Only the answers are evidence. So if a witness agrees with a fact or a proposition contained in a question, then the fact or proposition agreed to is evidence. However, if a witness disagrees with a fact or proposition contained in a question, then the fact or proposition is not evidence simply because it was suggested in the question. You would have to look elsewhere for evidence about that issue. You may not consider any answers that I've stricken. They're not evidence and cannot be used by you as evidence or considered by you for any purpose. The opening statement and closing arguments of the lawyers, not evidence. They're only intended to assist you in understanding the positions of the party. My instructions, anything that I've said during the trial, not evidence. All right. So if your memory of the testimony differs from the attorney's or mine, you are to follow your own recollection. You must consider the evidence as a whole. Now, I want to talk about direct and circumstantial evidence.
Before we get out.
There are two types of evidence that you may use to determine the facts in this case. There's direct evidence and there's circumstantial evidence. The law allows both direct and circumstantial evidence in a criminal case, and circumstantial evidence alone may be sufficient to establish guilt beyond a reasonable doubt.
I think a lot of people need to hear that too, because some people take this shit beyond a reasonable doubt. Unless you saw the shit happen on video in HD and 4K, it's not beyond a reasonable doubt. Some people take that shit so unbelievably to the ends of the world. You should replay that.
Circumstantial evidence in a criminal evidence. The law allows both direct and circumstantial evidence in a criminal case, and circumstantial evidence alone may be sufficient to establish guilt beyond a reasonable doubt. Direct evidence is when a witness testifies directly about the fact that is sought to be proved based upon what he or she claims to have seen, heard, or felt with their own senses. And the question there is whether you believe that witness or not. Circumstantial evidence is when no witness Circumstantial evidence is when no witness can testify directly about the fact that sought to be proved, but you are presented with evidence of other facts and then asked to draw reasonable inferences from them about the fact that sought to be proved. There are, however, several things you should keep in mind about circumstantial evidence. The first one is that you may draw inferences and conclusions only from facts that have been proved to you beyond a reasonable doubt. The second rule is that any inferences or conclusions you draw must be reasonable and natural based on your common sense and good judgment. In a chain of circumstantial evidence, it's not required that every one of your inferences and conclusions be inevitable, but it is required that each of them be reasonable, and that they all be consistent with one another, and that together they establish the defendant's guilt beyond a reasonable doubt. Inferences must never be based on conjecture, surmise, guesswork, or assumption. And whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all of the evidence presented in the case. Now, I want to talk about the credibility of witnesses. All right. It's going to be your duty to decide all the disputed questions of fact. You are going to have to determine which witnesses to believe and how much weight to give their testimony. You should give the testimony of each witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of the witnesses, and if there are any conflicts in the testimony, it's your function to resolve those conflicts and to determine where the truth lies. You may believe everything a witness says, or only part of it, or none of it at all. If you do not believe a witness's testimony that something happened, of course your disbelief is not evidence that it did not happen. When you disbelieve a witness, it just means that you have to look elsewhere for credible evidence about that issue. And when deciding whether to believe a witness and how much importance to give a witness's testimony, you must look at all the evidence, drawing on your own common sense and experience of life. Often it may be not what a witness says, but how the witness says it that might give you a clue whether or not to accept that witness's version of an event as believable. You may consider a witness's appearance and demeanor on the witness stand, the frankness or lack of frankness in testifying, whether the testimony is reasonable or unreasonable, probable or improbable. You may take into account how good an opportunity the witness had to observe the facts about which the witness testifies, the degree of intelligence the witness shows, and whether the witness's memory seems accurate. You may also consider any motive that the witness may have for testifying and whether the witness displays any bias in testifying and whether or not the witness has any interest in the outcome of the case. Now, I want to talk a little bit about prior inconsistent statements. When you evaluate the testimony the witness gave here in court, you may consider whether that witness made any earlier statements that differ from or contradict in any way their in-court testimony. That earlier statement is generally admitted into evidence solely for your consideration in evaluating the witness's credibility or believability. If you determine that an earlier statement is different from the way the witness testified in court, you may decide that the witness's credibility or believability is affected adversely, or you may decide that it's not adversely affected, but that is the only purpose for which you may use that earlier statement. You may not consider the earlier statement as evidence or proof of truth of any fact contained in the statement. Now, flip side, I want to talk about prior consistent statements now, all right? The testimony of a witness may be rehabilitated or supported by showing that he or she previously made statements that are consistent with their present testimony. The prior statement is admitted into evidence solely for your consideration in evaluating the credibility of the witness. Should you find the prior statement to be consistent, you may consider the prior statement only in connection with your evaluation of the credence to be given to the witness's present testimony in court. You are not to consider the prior statement as establishing the truth of any facts contained in that statement. Now, I want to talk about the defendant's statements that were made to evaluating psychiatrists or psychologists. You may not consider the defendant's statements made to a psychiatrist or psychologist in their evaluation of the defendant as establishing the truth of any facts contained therein. Those statements cannot be used by you as evidence of premeditation, extreme atrocity, or cruelty, or specific intent to kill. Such statements are admissible only as they relate to the basis of the doctor's opinion of the defendant's mental condition. Now, I want to talk about evidence of post-incident conduct. Now, if you have heard some evidence suggesting the defendant's actions after the killings, I'm not suggesting that these are the facts, because the facts are your exclusive domain. But there is some evidence to that effect, and I mention it here to describe the legal point that's implicated. If the Commonwealth has proven that a defendant did any of these things, you may consider whether such actions indicate feelings or consciousness of guilt by the defendant, and whether in turn such feelings of guilt might tend to show the defendant's actual guilt of the offenses with which he's been charged. You are not, however, required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances in this case. If you decide that such inferences are reasonable, it will be up to you to determine how much importance to give them. But you should always remember that there may be numerous reasons why a person not responsible for the crimes charged might do the things attributed to her. Such conduct does not necessarily reflect feelings or consciousness of guilt. So please bear in mind that a person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. So finally, remember that standing alone, consciousness of guilt evidence, if you find there was any, is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence that was presented at the trial. I want to talk next about expert witnesses. Now, there were a number of expert witnesses in this case, This term refers to witnesses who have specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their own personal knowledge, that is, things they have personally seen or heard or felt. Because a particular witness has specialized training in their field does not put that witness on a higher level than any other witness, and you are to treat an expert witness just as you would treat any other witness. You may believe all of the expert's testimony, none of it, or anything between those two extremes. There is no requirement for you to believe an expert merely because they are an expert. As with any other witness, it's completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and decide what conclusions, if any, you draw from the expert's testimony. You must, as has been explained, keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts as you find those facts to be, then you may reject the testimony and the opinion of the expert in whole or in part. You are also free to reject the testimony and the opinion of an expert witness in whole or in part if you determine that the witness's opinion is not based on sufficient education, experience, or that the testimony of the witness was motivated by some bias or interest in this case. All right? Now, you may have noticed that Ms. Clancy did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. Under our system of law, a defendant has a perfect right to say to the Commonwealth, quote, "You have the burden of proving your case against me beyond a reasonable doubt. I do not have to say a word," unquote. The fact that the defendant did not testify has nothing to do with the question of whether she's guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now, speaking of the exhibits, now I'm going to talk about that. You will have all the exhibits and the stipulations with you in the jury room. If there's a need to play an exhibit or view one, the court will make a computer available for you to use. The things you heard me say we're marking for identification only are not evidence, and you're not going to have those items with you in the jury room because they're not technically part of the evidence. We marked them so we could keep track of them as we went from witness to witness, and there'd be a clear record of some of the rulings I made. So coming back, however, the exhibits that were introduced in evidence, you'll have those with you. You alone will decide the weight that they deserve to receive in helping you make your ultimate judgment about whether the Commonwealth has proven its case. You're not required to believe something simply because it's written on a piece of paper or it appears in a photograph. You're not, of course, required to disbelieve it just because it appears there either. Whether to believe what an exhibit purports to show and how much weight to give the exhibit is entirely up to you to decide. Now, the view. Early in the trial, we drove by some sites and visited an address in Duxbury. As I told you at the time, we referred to that as a view. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the location and its surroundings. The view is part of the case. The observations that you made while on the view may be used and considered in your deliberations in reaching a verdict. Now, I want to talk a little bit about some photographs. The Commonwealth has introduced certain photographs depicting the victims. You'll have those photographs with you during your deliberations. The images depicted are not pleasant. As I instructed you at the time they were introduced, your verdict must not in any way be influenced by the fact that these images are unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence, and not one based on pity or sympathy for the decedents, which might be occasioned by the images depicted. Consider those exhibits only as they may draw attention to a clinical medical status, or nature of the victim's injuries, the cause of their death, or to the nature of the incident itself. Now, about notes. At the outset of the case, I spoke to you regarding the use of notes, and I want to repeat it this time. Your notes are only an aid to memory and should not be given any precedent over your independent recollection of the facts. Whether you took notes or you didn't, you must rely on your own memory. Do not use your notes to try to persuade your fellow jurors of the accuracy of your reflections, and no juror should be influenced by the notes of other jurors. Your notes are not official or even unofficial transcripts. All right? Now, I can answer it by anything other than...
This is the jury instructions, I guess? Sound like it. Sound like it. I'm already over it.
To communicate, to try and look. Don't talk to anybody while you're deliberating. Don't try and look up anything, things like that. All right? Just kind of make that as clear as I can. Now, before I go any farther, I have to do one more duty. That's to select a foreperson of the jury. We have a foreperson for two purposes. The first is to act as your facilitator. That's to gather everyone around the deliberation table to be sure that everyone has a full and fair opportunity to speak and to share their views, and to ensure that all of you are always deliberating together as a group as you work to reach the verdict in this case. The second purpose of the foreperson is to act as your spokesperson here in open court. So when you're ready to return your verdict, we'll bring you all back out as a group. We'll ask you to remain standing, and we'll ask the foreperson on everyone's behalf if you've reached a verdict. And if you have, we'll go through the process of having that verdict reported by the foreperson on your behalf, and then it's recorded in the case. All right? So those are the two roles of the foreperson. So in this case, I'm going to appoint in seat 18, juror number 257 as the foreperson of this jury. Okay? Now, members of the jury, if during the course of your deliberations you should have a question about the law or about my instructions on the law, and by telling this, I'm not suggesting you'll have one, but if you should do the following. All right? You should all first agree on the form of the question, have the foreperson write it down on a piece of paper, and the foreperson should give it to the court officer, who'll bring it to me. I'll call the lawyers together. We'll consider your question and how I should respond to it, and then I'll either bring it back out here in the courtroom and respond to you here in open court with an answer, or if it's appropriate, I might just write the answer down in response to your question and send it back to the jury room. So now that process accounts for, may cause a lag time between when you ask the question, get it sent out here, and I meet with the lawyers, decide how we answer it, and get the answer back to you. So if you can continue to keep deliberating while waiting for my response, by all means do so. If you cannot go further without my response, then stop, and I'll get my response to you as quickly as I can. If it's necessary to communicate with me on any matter during the deliberations, I'd ask you to do so in writing. Send me a note, and I'll respond to it. You're instructed not to talk to anyone else about any aspect of the merits of this case during your deliberations, and that includes the staff, court officers, lawyers, witnesses, parties, family members, friends, acquaintances, anyone. All right? Now, your communications with the court officers should have to do, really just matters of scheduling and breaks, when you come back to the courtroom, that kind of thing. But even with them, don't discuss what's going on inside that jury room if you can. And then while you're in the jury room, you should all talk about this case only in the presence of each other. That is, at some point, we'll have lunch brought to you. So if you'd like, you may as a group decide to suspend your deliberations, have lunch, and then return to the...
Why can't they have lunch back there? When I was deliberating on a jury, they brought the lunch to us. We got to order whatever we want. They brought it in. They were eating and deliberating.
Eating lunch separate from others while deliberating. All right? So no subcommittees in a sense. What you do as a group. All right? You do it all together. Now I'm going to get to a difficult part. Reducing and sending out the jury. All right? When we impanel a jury at the beginning of a trial, we never know whether some personal emergency will arise or during the course of the trial, which would require one or more of the jurors to be excused from further jury duty. To avoid having to start the trial all over again, if that should occur, we impaneled, in this case, 18 jurors, even though the case will be eventually decided by 12 of you. And we made that decision because this is a lengthy case, over the summer. The time has now come to reduce that number. This is especially difficult in this case, where all 18 of you have been equally dedicated and attentive to this case during the course of this trial, but the case is to be decided by 12, all right? And so the way it's done is the clerk will draw the alternates' names, we put all the numbers, the exclusion of the foreperson, and then we'll draw out the names randomly for the alternates. And the purpose of the alternate, for those of you who are selected, is that even during the course of deliberations, sometimes things happen. You know, one of the deliberating jurors gets sick or a family emergency, and so we may, and it happens fairly regularly, they would have to substitute one of the alternate jurors into the deliberating jurors, because if we didn't have the alternate jurors still here, we'd have to start all over again. So that's why we do it. It doesn't make it any easier, but I thought I'd just explain to you why we have to do that. As I put in here, fate makes you an alternate juror. Don't take it personally. Your presence to this point and continuing availability, if you should be needed, is an important contribution. The court officers will make you as comfortable as possible while the jury deliberates. If you're an alternate juror, you should not discuss this case with anyone at all while the deliberations are ongoing, nor discuss it among your fellow alternates, as the need might come up that you have to join in the deliberations. So in other words, the alternate jurors can't have their own kind of informal deliberations, and it's very difficult, but I just kind of want to make that clear, that you have to do that, or you cannot do that. So at this point, I'm going to ask the clerk to reduce the jury at this point.
The following jurors are chosen as alternates. Juror number 157 in seat number 11. Juror number 162 in seat number 12.
Asleep, he's asleep. I think they kick you out if you fall asleep. Oh, this is gangster, man. Oh, shit.
Juror number 385 in seat number 14. Juror number 122 in seat number 6. Juror number 124 in seat number 7.
Bingo.
And juror number 245 in seat number 15.
All right, thank you. Now, what I kind of forgot to talk about, I mentioned it with the foreperson and everyone in regards to the verdict, just the verdict slip. This is the verdict slip. This is what it looks like. There will be a verdict slip for each count, and it says right there's a count regarding Cora Clancy, there's a count regarding Dawson Clancy, and there's a count regarding Callan Clancy. And on each of those, there's a box for not guilty by lack of criminal responsibility, guilty of murder in the first degree by the theory of deliberate premeditation or extreme atrocity and cruelty. There's a box for guilty of murder in the second degree. There's a box for manslaughter. So when you have reached a unanimous verdict as to which verdict it is, the foreperson is to check that box that is applicable to the decision, sign it and date it, and let the court officers know that we have a verdict. Okay, so it's pretty self-explanatory, but I just kind of wanted to let you know that. Now, I know I'm not telling you anything you don't know when I tell you that reaching a verdict in this case is not necessarily going to be an easy task. It's going to require conscientious service on your part and a conscientious approach to your duty as jurors. I suggest, respectfully, that each approach it with a mutual respect for the opinions of your fellow jurors. They have a disposition to listen to each other. Don't be afraid to change your own opinion if the discussion persuades you that you should, but don't come to a decision simply because other jurors feel it's the right decision. It's your decision, all right? Each of you must decide this case for yourselves, and you should do so only after you considered all the evidence, discuss it fully with your fellow jurors, and listen to the views of your fellow jurors. You all heard the same evidence. You've all heard it with the same degree of attention. You're all governed by the same desire to arrive at the truth, and you're all under the sanction of the same oath that you took as jurors at the start of this trial when you agreed to well and truly try the issues between the parties in accordance to the evidence and the law. Now, I'm about to submit this case to you, and I need not remind you that you have an awesome responsibility. But I believe that you will bring to bear all the wisdom and the judgment and the conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide this case with integrity and with principle. Now, everyone has feelings, assumptions, perceptions, fears, stereotypes. Those are implicit biases that we may not even be aware of. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. Because you're making such an important decision in this case, I strongly encourage you to evaluate the evidence carefully. Resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence, your individual evaluations of that evidence, your reason and your common sense in these instructions. Our system of justice is counting on you to render a fair decision based on the evidence and not on biases. Please have confidence in what you're about to do, all right? I have that confidence in you. I don't think I've ever seen a more dedicated group of jurors in any trial that I've ever been involved in. You're all people of intelligence and common sense. Collectively, you're bringing a truly powerful force to determine the truth of the matters in this case. And I, as I said, have great confidence with this case in your hands. You're honest, thoughtful, and fair, and be that as you took the oath to be. I am completely confident they'll be able to arrive at a just verdict, whatever that verdict may be. So at this time, I'm going to ask if I could see counsel at sidebar just for a second, and then we'll have the clerks swear in the court officers, and then you'll be sent out to deliberate.
Okay, that's it. Chimichanga. So the poll is in the chat. Again, sorry about all the issues, man. I've been having a lot of issues with the streaming, and I had to disconnect while leaving the live stream up and reconnect and restart all this stuff. So, but anyway, it was a good thing that we could test it out, and we haven't had any audio issues since I came back, which I think it's been an hour and 40 minutes. I think we've been good. So I hope that's it. Made some changes. Hopefully that's the resolution to it. So yeah, the poll in the chat is, what do you think the jury would decide? Guilty first degree, guilty second degree, manslaughter, or not criminally responsible. 48% say guilty. Guilty. And then 31% say not criminally responsible. I am Lindsay. Same Lindsay. You know, they feel she was not there, wasn't premeditated, like mentally there. Let me play. So I was sent this clip. Let me just play a little clip here. I got a couple more things I got to do after this stream. Touching buttons that I probably shouldn't touch. Let me play this here. Blah, 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 blah. But I hope that's it. I'm happy. If the stream is fixed, I'm happy. Then we can go back to normal when we cover all the breaking stuff. We don't have to worry about whatever it is.
Did Lindsay speak when she was outside on the ground? Because it was confusing that the psychiatrist said that Patrick said she did.
I wouldn't believe him if he said in the middle of a blizzard that it was snowing out, okay? So I don't care what the psychiatrist said. You heard that, well, no, you didn't, unfortunately. If you were in the courtroom, you would have heard the tape. She was unable to speak. She just moaned and made grunting noises, that's all.
So why would Patrick say that?
How do I know?
Oh, that was really interesting. So a lot of people think that Patrick is like involved or something like that, right? And so let's see here.
Did Lindsay speak when she was outside on the ground? Because it was confusing that the psychiatrist said that
Patrick says she did speak. The kids are inside. Go to the basement, blah, blah, blah.
said she did.
I wouldn't believe him if he said in the middle of a blizzard that it was snowing out, okay? So I don't care what the psychiatrist said.
And it's a little ironic that you don't care about what that psychiatrist said, but you care about all the elements that benefit your client. But I get it. Everybody has biases, even medical professionals.
You heard that? Well, no, you didn't, unfortunately. If you were in the courtroom, you would have heard.
Even though you're not supposed to be biased, you're supposed to be just presenting facts. You're being called, you're testifying, you know.
Heard the
Lindsay Clancy's lawyer calls her a darn good mother. That ain't no, well, people say before, I just can't, bro. I can't conflate the two, but people say before she was a loving, doting mother, you know. The shit that gets me the most, I think, in this whole thing is how she apparently took one kid to each room to separate them. That's a little bit of thought there, too. Separate them. You can kill them sneakily one by one so the other one doesn't notice, and you sent this guy out. You did plan this shit. Maybe the voices were telling you, you know, but you planned this shit. And you send him out to go to CVS and to go to pick up some food, and you know you had a time window. And then you methodically took each kid to each room and did what you did. And not one time while you're watching your child die, not once while you're the one causing it, not one time in your head, the voices are telling you to do some shit, but you're not one time you're like, you know what? Fuck the voices. You know, I don't know. Like, that's crazy. And one by one by one. And then I don't know, the prosecution during the bits that I heard, because I was all over the place. Prosecution was saying that, like, you know, she feigned this stuff. Kind of like, well, that she didn't take enough pills and she's a nurse. She would know what to take. I had an ex one time feign the shit. I had an ex one time. She came to my mother's house. Let me in. Let me in. I said, no. Let me in. I remember one time, too, she was like burning her skin or some shit. What's wrong with this bitch? But she wanted to come back in. It was toxic. And I'm like, no. And so she's like, I'm going to take these bottle of pills. I was like, what? And so she like left. But it's all a performative thing for her because she, and the other thing, too, is, you know, my father, he unalived himself a long time ago. Well, 2010. And she knew that. So people, when they know some of the things that they think they can use to manipulate you too, you know, they'll use it if they're that kind of person. And so she left the empty bottle of pill. I don't remember what it was. It was ibuprofen or some bullshit. I don't remember what it was. And she takes off. And so I go outside to confirm, and there's an empty bottle of pills. And I was like, you know what? I'm calling the cops on this bitch. Because one, you're disrespecting my mother, the house. She wasn't home, but like, you're going to pull this shit off here? So I called the cops. I said, yeah, she's in this car, this done. She said she took the whole bottle of pills. Go find her. You might need to take her to the hospital. And they found her ass. And they found weed in her car. And they took her to the hospital. But it ended up being she never took any pills. She never took any pills. I'm not saying that's the case for everybody. You know, I'm not saying that's the case for everybody, of course, but this is a tough case, man. It's a tough case. Matt Walsh tweeted 27 minutes ago, and he said, every artist, murderer, predator in existence has mental health. Okay, mental health. Oh, wow, that's kind of a lot of zooming. Okay. By the standards of a normal person, they're all sick in the head. They all have intrusive thoughts. And a huge number of them have far more serious sob stories than Lindsay Clancy. Most of the worst people in the world who do the most depraved and horrible things were mistreated as children, subjected to all kinds of horrific abuse. Pick any serial killer at random, you'll likely find he had been victimized, mistreated, even tortured for years. Many of them can claim they were abandoned by the system much more convincingly than Lindsay Clancy can make that claim. Yeah, we all agree in almost all these other cases that the sadistic predators, in spite of the significant mental health challenges, whatever terrible things were done to them, must still be fully held accountable. I don't know. Lindsay has a lot of support. So Jackson, I love intrusive thoughts. I have thoughts every day too. I mean, I don't want to talk too much about it, but I tripped on LSD a long, long time ago, many years ago, before my daughter was born. It was a bad trip. Oh, I had all kinds of fucking crazy thoughts. It was a really bad trip. I had all kinds of crazy thoughts. The shit was telling me, I wasn't hearing voices, but there was these thoughts coming into my head that I knew I still had my sensibility about me a bit that I knew were illogical, didn't make any fucking sense. And I was having a hard time distinguishing reality from, oh, wow. Katerina, what are the chances? This is a tough one to cover, though. Let me see. Let me send this to Layla. Maybe look into, oh, gosh.
He's got his kind of salad there.
He's kidnapped her.
He's kidnapped her?
Yeah, that's what she just said.
Wait a minute,
You messing? Apparently he's kidnapped her.
What? What the hell? We gotta start a new stream, mate. I thought I was gonna take a break. I thought I was gonna eat. I thought I was gonna mess with the computer, but now we gotta get back live. Oh shit! What the hell's going on? Hostage?
Bullshit. Yeah, all the time.
What's like 10 feet up in the air? 5 feet up in the air? What are we doing here?
People go stand with me.
Oh shit! What is that?
It's actually fuck my pussy. It's actually fuck.
What the hell? Oh, some ads just started playing. Katerina, okay. I don't know what kind of live, how we're gonna do this. What kind of title? What is it in the UK? Also, what is going on, man? We're international today. I'm ready to kick back. Not kick back, but kick in. Get ready back to streaming. Let's listen in. Let's see what we can. Oh, she has the music. Oh shit. I guess she's playing music. I don't know what. Her. I don't know why are we doing this Celine Dion shit right here? This person's at the window. Let's see, Katerina. Yeah, dude. Where the hell did she go?
Just off. I've seen the window. I'd love some
Who's his desk?
Oh, you've bought us some dinner, mate. It's ours. It's ours.
That's
You order food.
What number are you looking for?
Number 3.
What number are you looking for, mate?
Is it 3 Glen Almonds?
What number?
Oh, you guys can't even
This is
see.
number 3.
Oh shit! It's all zoomed in and stuff.
Well, we've not ordered food. It's number 3. 3 Glen Almond, but we haven't ordered any food.
That one behind us.
Is it Glen Almond?
Come on.
I'll have it like if it's going. We love Smash King. Fucking hell. He's just nearly give me a free food. Someone's ordered food to my house. Someone called Steve. Nice one, Steve. If I was a nasty person, I would have just took that and fucking scrambled his smash burger.
What's she saying? No, we're not doing a verdict watch. We'll come when the verdict's here. Damn.
Harrison, move.
out the window. So how are you charging your phone?
Got the essential news.
Blimey.
Mom, is it put it on?
All right, Josh Robbo. Everyone follow Josh Robbo, CH44. He makes the best tuna fish song.
Is Josh alive?
Say, man has said tuna.
Man said tuna.
All right.
Is Josh alive?
I don't know.
Tuna. I hope you fall. Look. Ben. How long has he been sitting there for? Like about an hour. Why would he be?
He's done it for you.
He's done it. I'm not putting him out in for my team. I'm bringing it back with it in a takeaway box. He hasn't shown within half an hour, bringing it back with it in a takeaway box.
Oh, he's been threatening. Somebody said it. Copy this shit.
Comment then.
He's kidnapped his girlfriend. Oh, sorry, wrong button.
Pancakes are gorgeous.
I like pancakes. I don't like pancakes.
Getting boring.
Giorgio.
That kid said it's getting boring. That's what that kid said.
If he hasn't jumped within when my team from now to when my team starts.
Yo, these kids are savage.
I'm just going to push him off the reason. Like before he was in. He was in. So they couldn't.
Mate, your comment just absolutely disappeared there.
Imagine he just.
It's like catching a fish.
No, they probably got in, yeah, but not gone in like his flat. If he just slipped off. Like, ew, it's that. Ew, it's that, man. No, he's being fun. Who? Wait. I'm thinking.
I've gained like nearly 7,000 followers off this live.
97,000?
Even the firefighters and all that. And the police do stand there. It's like, yeah, the firefighters are talking.
Thanks for all the gifts, guys. Defo having a big fat chippy tonight.
Yeah!
No, the kids are cheering. I don't know what kind of crazy shit is this.
Look how many
That's how they do it in the
people
UK.
tried to join them.
Oh, blimey.
How you get so many fucking kids? 25 people have tried to Firefighters and everything could just go message for us now.
I've got 1.4 million likes.
Do you?
Yeah.
My ma's famous. She's got 1.4 million likes on TikTok.
Guess we'll do it.
Where's the money? In a bank. Firefighters are that bored that they're probably talking about what they're going to have to say. Probably going to do that.
I will, I'll update ya.
Like, this is getting a bit boring now. Just jump or going. That's not pancakes on him. What? That's not pancakes on him. There's a pancake. When pancake make them slip and fall. Got some pancakes right up there.
Oh, we're gonna start a new stream, I guess, guys.
So much jelly, you might have a
See what's going on here.
Harrison, imagine he just tries to move and slips off. I hope he does.
He's just chilling too.
I'd start laughing. So bad. Mum, you're so lucky I don't have my phone. I've got about 700 new TikTok videos. No one in probably falls off. Hey, it's a policeman. I don't understand. Do your job. Do your job. I'll shoot the police.
Thanks for the gifts, guys.
She's not actually thank you. She just wants to get more. She says thank you.
Shut up, will ya?
Stop sending her gifts. Yeah, exactly. But you could. You run these good.
I want the TikTok on my iPad.
Might just say if you give me a 10, I'll go up that.
1.5 million likes, guys.
Easy job done, and then they can arrest
Right,
you.
who is this geezer walking back and forth? Who's this geezer? That's the FBI.
It's the FBI, it's not America. It's fucking FBI.
SPGG.
It might be an undercover cop or something. Yeah, probably is. Because undercover don't have blue.
Who's that boy? Well, the boy who just went in.
He's battered his girl, kidnapped her. And police have brought his door through. And he's threatening to jump out this window now unless they go.
No, I'm not even. I'm not doing it already.
Thanks for all the gifts.
No, she's not.
He wants to sing that song again.
The piggies. Hassan, there's your best friend. The pig. Wear a skirt then.
2 years wearing pants.
Wear a skirt then.
And then that's what I'm going to do. I'm going to go there wearing a skirt. And if they really want to kick me off for a skirt, fine. Kick me off. Don't want to go to school anyway. Just got forced to go to school, really. It's cool to go to. For God's sake, Grace, can you just jump already?
Yeah, she's in one of the police cars down there.
She got knocked out.
She'll be back out. She'll be back there, Shannon, in a few days. No, yeah, they'll be loved up again in a few days.
Move, Harrison. Harrison! Harrison! Move.
Get me the camera and that move.
So what put on your mum's?
All right, I'm gonna transfer you guys. We'll check it out for a little bit and see what's popping. I'll try to see if I can find information on this. I haven't seen nothing yet besides this in the chat in the UK. It seems like a DV situation, allegedly, according to the chat.